Hello students, how are you? And this is Dr. Vardhan Suman. We have brought another suitcase for you. Not obviously that suitcase. It is suits and cases. And the suitcase we have today with us is talking about a case which is given on page number 219, that is 219 of paper 6 of ICMAI, that is Law and Ethics. And the case title is ESI Corporation Odisha Region versus Gujarat Cooperative Milk Marketing Federation Limited. You have got it right. This is nothing but the federation which is owner of the famous brand Amul. So this case is about Amul. So in the Cuttack region of Odisha, Amul was operating and manufacturing and selling dairy products. These dairy products were being transported by a C&F agent. The name of that C&F agent was Lakshmi Agency. So, when it came to the knowledge of ESI Corporation officers, they issued a notice that stating that Amul and Lakshmi Agency are not two separate entities. They should be considered as one. Amul, that is federation, shall be considered as principal employer, and Lakshmi Agency shall be considered as immediate employer, and the strength of both the federation and agency must be clubbed. And after clubbing the number of employees, it was more than 20. And therefore, the ESI Act shall apply on federation as well as the C&F agent, that is Lakshmi Agency. Against this order, Amul went to the High Court, stating that the order is void. Order is bad in law. Why? Because Lakshmi Agency has nothing to do with the management of federation. Lakshmi Agency is a separate unit and both the units cannot be clubbed. Number 2, the ESI Corporation has also included employees who are drawing more than 21,000 rupees per month in the category of employees, which is also bad in law. Why? Because employees getting salary of more than 21,000 are not employees as per ESI Act. The court held that both the federation, that is Amul, and C&F agent are different entities. So their number of employees cannot be clubbed to ensure whether the ESI Act shall apply it or not. Number 2, the employees who are drawing salary more than 21,000 cannot be considered as employee under this act because that is written especially in the act itself. The court also stated that yet we have a duty of liberal interpretation in case of labor welfare cases, but we cannot put our step beyond the limits and boundaries of the legislation itself. So Amul's contention towards the order was upheld by the High Court, and the High Court stated that both the entities are different, their employees cannot be clubbed, and since number of employees working in federation and Lakshmi Agency separately are less than 20, therefore ESI Act cannot be applied on them. So, how was your experience with this case law? How was your experience with this suitcase? Please mention in comment. Till then, happy learning and thank you very much.